This courtroom is about to explode with confusion, interruptions, and a defendant who refuses to cooperate. Keep watching because Judge Boyd is seconds away from losing patience.
Hold on a second. Good morning, you're Traylon Hill. I don't see, what is it?
It's a motion for continuance, filed by Mr. Matuska, Your Honor.
You just paid the bond before.
Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? I don't see the motion is what I'm looking for. It may be one of the...
Which cases that order?
All four.
This moment may seem small, but it shows how chaotic court days can get. Judges handle real cases, tech glitches, impatient defendants, all at once. What would you do if your computer froze during a live hearing?
I just got a script error. Do I hit yes or no?
Yes, it's fine.
Sorry, now my computer's acting up.
Did you try it? Did you try it?
Huh? I haven't seen it yet. It's not even showing up, but now I've gotten to where I can't X out of anything, so. All right, so Mr. Hill's cases are set for trial to begin with jury selection next week, and Mr. Matuska, you filed a motion for continuance.
Flag. When a defendant refuses to review evidence with their own lawyer, it slows the entire case, and sometimes signals deeper mental health issues. And Judge Boyd picks up on that instantly.
Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all the written reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me, to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based on...
Don't talk, I'm going to talk to you in a minute.
I'm just saying.
Don't talk over people.
I'm not talking over him, let him know.
You're talking over me right now, and you're talking over him.
I own him.
Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons
I haven't been out to the cell in over like
that the court may be
5
aware of.
weeks.
But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing to do that.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr.
Listen to
Hill
the
is very...
frustration in his voice. He's been to court 14 times and still claims he has no evidence. But the judge cuts him off immediately. When a defendant keeps firing lawyers or refusing cooperation, judges see it as delaying
be
tactics.
done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay?
Cool.
So
I
it's...
paid for Burbank, I don't even know who this is.
So you, Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your
You
lawyer.
can put up his file
I represent,
on TV.
I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is 'cause
listen.
I've been to court 14 times and I'm looking to go because I have no evidence on me.
Listen,
during this whole entire thing.
you and me both are ready
So
for
y'all
you to
invaded
go.
y'all invaded
Both
my
of us are ready. Go back with the bailiff.
Y'all invaded my
Listen, if they
business.
come out to visit
All my
with you, you need to visit with
constitutional
them. Go back with the bailiff.
Hey, watch where you hold me, sir. Don't touch me like that. They ain't gotta touch me. I know how to walk, sir. All right, you don't get it at all.
Your Honor, after the evaluation, if there's maybe another way that we could order some kind of sitting where I can at least give him the opportunity to see him.
Yeah, I can, what we can do after that's done and we get it, if we need to, we can have him, I'll contact the jail and see if we can either have him brought here with guards or you somewhere at the jail where I'll order that they force him to go. Okay.
right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Judge, we are, and there's just one matter I need to speak to.
Yes.
Judge, given after reviewing the facts with the complainants, given the quality of the case, the state and the defense were able to arrive on this as what we felt was an acceptable resolution for all parties. My client has been on bond, on GPS, without incident for almost a year.
This no-contact order is strict, and Judge Boyd is crystal clear. Even accidental contact can violate bond. And in many cases, jail phone calls expose defendants instantly. These warnings aren't for show, they're legal landmines.
For a very long time, he was on full house arrest and wasn't able to earn a living. He's just now in a position where he's getting back on his feet. The state has no objection to me addressing the fine. I'm asking the court to consider probating all or part of the fine. And I look forward to my client continuing to perform on supervision the way he has in the last year.
All right. So what were your issues? Why did you do this?
So Judge, if I might speak to that. Obviously we all agree that no threats were made in person.
Mm-hmm.
There were some allegations that threats were made over the phone.
Mm-hmm.
At some point, obviously the state took this very seriously. Initially, we were talking about jail time. At some point, after looking at the case, we agreed that a deferred was more appropriate, more in keeping with what happened in this case. My client contends this was a big misunderstanding. His appearance when he showed up the next day caused concern.
What was the misunderstanding?
So I think there's language basically. So, Your Honor, like what I was in full rest. The company has to post signage, proper signage to.
So Mr. Garza was open carrying. He did not believe that the signage at the store complied with what's required by the law. So he did not believe that he was in violation to open carry at the time. Given his conversations with his dissatisfaction with some issues at the store, the product he received,
So
he shows up open carrying. Everything kind of went bad from there.
All right. So according to what I've read in the STIPs, and everybody correct me if there's anything wrong in the STIPs, it says that he's upset over some propane tanks.
There was a dissatisfaction with a product.
And instead of just going there and saying, hey, your policy is gift cards, I'm not getting a new propane or something else, you're not getting the money back. All you have to do is accept that. And then if you want to go sue somebody for not giving you money back, then that's what you do. But you don't call on the phone and then show up with body armor. I mean, that's what it says in the STIP.
And the idea that him showing up in that obviously caused a great deal of concern.
Mm-hmm.
The police were called out. He was arrested without incident. He made bond and he's been supervised without incident ever since.
Do you have any children?
No, Your Honor.
All right, probation. This is what the court is going to do. It's $1,000 fine to be probated, 6 years deferred adjudication, continued GPS partial for employment only, no employment as a home health care provider or with minors, no possession of body armor. I already know there's no possession of weapons as well, but I want you to understand me clearly. That's why I'm saying no possession of body armor, no possession of weapons. Do you understand?
Yes, Your Honor.
150 hours community service restitution. I'll order the stress education course. Once he's completed that, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. You all do a referral to Veterans Treatment Court. There should be no contact with HEB. You're going to have to go somewhere else other than an HEB.
And he's been going somewhere else. I think HEB doesn't want him there either. So.
And there's to be no contact with the following persons: Seferino Lopez, Diane Lucera, And there's to be a mental health evaluation. And a TAP evaluation. Out of custody, follow all recommendations. Regular reporting by Zoom or in person, regular random UAs. Probation, is there anything else? Yes, or with minors.
Yep.
And there's to be proof of employment within 45 days.
And Judge, he does work, kind of does freelance work, and he's been doing that consistently. The court adjusted his probation, his bond conditions to allow him to do that.
Yes.
You know, he's been complying with the court's orders and that. So we'd ask that if the court's going to keep on GPS and be in keeping with what the adjustments were made on the bond conditions.
Oh, yes, he's allowed to work.
Yeah.